It was yet another start and stop in the decade-long murder mystery. Just as the cross-examination of cell phone data analyst Gideon Gous was due to resume, the defense accused the state of being dishonest and supplying crucial documents piecemeal. This, they said, jeopardizing their defense.
There's also new information which has just surfaced, and that is got to do with accused number 3, my client. There's also a very mysterious number that is now resurfaced in terms of the document that has been sent overnight. There's also a new number, and all along the state was asserting that accused number 3 is not affected by these cell phone records, but all of a sudden there's a new number. I haven't consulted that. I don't know where the number comes from or applied for that number. How does it really affect him? How does it really affect him so far as this case is concerned? Those are all the concerns that I have, that I also need to study these documents, these voluminous documents. But if the court can just look at these voluminous documents, and I'll also have to study them and go and consult with Mr. Mure in order to get proper instructions.
My Lord, I wish to confirm that I've also received additional information this morning, which was not supplied to me on Tuesday. On top of that, my Lord, on the affidavit of Lieutenant Colonel Lewis, he also says that when he analyzed the numbers, there is also SMSs, communication through SMSs that I've requested from the state to provide me in order to further consult with my client.
So you haven't got those SMSs?
Yes, I haven't received those SMSs.
It had been the third time that the case did not sit due to outstanding documents.
This morning I received another bundle of documents from the state, of which I have not been able to read them. I can see also the email was sent last night at 2300 hours, of which I was not told not to sleep and wait for this email. Unfortunately, I couldn't read it overnight. As a result, my Lord, I would like to place it on record that this is a trial by ambush, my Lord. Yesterday I had all the day to consult with my client on all the documents that the state is preparing or anticipating to use. However, the documents were not supplied to me, especially the affidavits which were marked by my learned friend, Mr. Baloy, that there are pages that are missing. And my Lord, what is very bad in this trial is that the state is dishonest with this court. The state is not telling the truth in this court, that they need time to investigate and to compile all the necessary records that are supposed to be supplied to the defense, so that we can be able to consult properly and then be able to run with this trial. Now, Mr. Host,
I strongly object to the language employed by my learned friend, say that we are dishonest. We are officers of this court, will never be dishonest. No, English is not our language, but I suppose that's not really what, or I want to believe that's not what my learned friend is implying, but we will never be dishonest.
Okay, thank you, my Lord. They are honest. The state is honest, my Lord. I'm changing from dishonest to honest. The state is honest. My Lord, the witness is called now to the witness box to proceed with this trial, whereas we are being supplied with information which is relevant to this witness this morning.
That's why one will be tempted to say they are cooking, they are manufacturing day in, day out, so that it can fit what the state wants to do. Because I can tell this court now, they don't have a case. I'm not arguing the case, but I don't see the purpose of this witness to be here. Number two, this disclosure, what time do we have to go through? Because if you consult with the client, sentence by sentence, transaction by transaction, is this fair? Is it fair trial to this accused?
At least one legal analyst says the defense is correct, as the cell phone records are crucial.
They should have received their documents, before the trial began. That is why we have what we call a pre-trial conference, where before the trial starts, all the documents and all the witnesses that will be used by the states are given to the defense to say, this is the information or the evidence we'll have during the court trial. That is why we need to focus on Section 35, subsection 3, paragraph I, which says every accused in the trial has a right to adduce and challenge evidence, which means the evidence that he has to challenge or she has to challenge must be given to him in time so that he or she can prepare. Now, my concern on this matter will be, this matter, remember, it started de novo, meaning it started afresh. This document should have been available in the first trial. This document should have been available on the pre-trial of this matter. So it's a concern that these documents are given in piecemeal, inverted commas, if you will. So I think that the defense is correct in saying this is not the right way of doing things when such a prominent case is being done. Even if it was not a prominent case, just sticking with the constitutional rights, it was important that, they got their documents in time so that they can prepare. In relation to the cell phone evidence, my view is, yes, in the beginning, if we followed the trial, the accused stated that they don't know each other. And when the matter proceeded, it was clear that, there is some connection, there is some cell phone communication. Therefore, as the matter is continuing, the state is saying they have evidence that the accused have been communicating with each other, which I think is crucial to show that the accused know each other. And it also puts the accused possibly in a bad light in the sense that they are not trustworthy in saying they don't know each other. However, the main thing is the accused have been charged with murder, and the state must prove beyond reasonable doubt that all 5 of them are involved in the murder. So them knowing each other is crucial to show that they do have knowledge of each other. But if we look at it holistically, are they the ones that murdered Senzo Meyiwa? Maybe it's just circumstantial evidence that would assist to a certain extent, but the main issue that the state has to prove is the accused are the ones who murdered each other. Then, of course, there are outstanding issues that one may have a concern with, where the state says, or the state is using evidence that there is a mastermind, but there's no mastermind that is arrested. And then there's a docket of 375 of 19, which is another issue that is possibly, an elephant in the room. But at the end of the day, it is concerning that the accused will say they don't know each other, but they know each other. But what does it prove, holistically? Does it prove that they murdered Senzo Meyiwa?
Cell phone data analyst Chriselda Lewis is expected on the stand on Monday. Chriselda Lewis, SABC News in Johannesburg.